I have hit the button, and we'll see what happens when YouTube says we have an excellent connection.
Sounds like
And
YouTube's
so
hitting on you.
we have an excellent connection with YouTube. Oh, yes. So right, swipe right on YouTube. Or is it left? I don't know. Either or, I
I
guess.
don't know.
Hello, everyone. Welcome, welcome, welcome. Happy New Year from Esch sur Alzette, Luxembourg. It has just passed, well, I say just. The last 41 minutes went pretty quick, you know, when you've got some brute and a whole bunch of live streaming equipment to set up. Welcome, everyone. Today we're going to talk about this company, Prenda Law. You may be familiar with them because we've talked about them a lot on our channel before. Prenda Law is a very, very famous copyright troll that back in 2012 or so, according to Wikipedia, they made around $2 million. Of course, my banners and things are in the way. They made around $2 million copyright trolling, but it turned out that they didn't properly conduct their operations so improperly that Paul Hansmeier and John Steele were charged with basically racketeering, RICO, fraud, wire fraud, some sort of money laundering, maybe even tax fraud. And so 3 attorneys were either sanctioned or convicted. John Steele is in jail for 5 or so years. Paul Hansmeier is in jail for, I want to say, like 12 or 14 years or something like that. And before they actually got prosecuted, it took years to prosecute them. It wasn't until like 2016 that the bar caught up with them, and it wasn't until 2018 or 19 that their actual case caught up with them and they were actually tried and sentenced. So in that sort of meantime, Paul Hansmeier had also gotten into prosecuting these Americans with Disabilities Act claims, and that's an okay thing. Like we don't actually mind if there's a Disabilities Act violation. I'm going to adjust one of my lights here. If there's a Disabilities Act violation, it's more or less, we can discuss all day the merits of that. But these Disabilities Acts violations were questionable, and I think he was also threatened with further charges if he continued to prosecute or pursue not quite legitimate Disabilities Act violations. Like, if you have a store that doesn't have a access ramp or something, when does that become a violation? And it's not always a violation, but he would prosecute them anyway, if I recall correctly. Some of this is speculation because we don't have all the details on it at our fingertips. Today, though, in an effort not to make this a 3-hour-long live stream, we have a memorandum in support of a consolidated motion to dismiss. Consolidated because there's 2 case numbers here. Paul Hansmeier brought 2 cases against the U.S. Attorney for the District of Minnesota, Erica McDonald. And the reason why he did that is because she's one of the U.S. attorneys that was involved with charging him in the first place with the whole Prenda Law copyright trolling honeypot scheme. And so now he wants to run a Americans with Disabilities Act lawsuit system, and he wants to run another copyright trolling, what I'm going to call a honeypot scheme, from prison. He's currently in prison and will be for the foreseeable future. Even on good behavior, I think he has to serve 85% of his sentence. Although I'm guessing based on professional experience and not based on actual knowledge of that. So, but let's go over. This is her, Erica McDonald's, U.S. Attorney for the District of Minnesota. This is her memorandum in support of a motion to dismiss his case. And she goes into details, which is why I'm just going to read this and we're all going to just enjoy it. Before we start, let me take a look at our viewer activity here and say hi to everybody. It looks like there's 200 plus of you watching. So Happy New Year to everybody who's already in the new year, and happy almost New Year to everyone who's coming. Let's go back here and take a look. Defendants: David McLaughlin, Benjamin Langer, and Erica McDonald, the federal defendants, by and through their attorney, Erica McDonald, the U.S. Attorney for the District of Minnesota, and the Assistant U.S. Attorney, Kristen E. Rao, submit this memorandum of law in support of their consolidated motion to dismiss the matters. Pro se plaintiff, which means he's representing himself, Paul Hansmeier, currently incarcerated at the Federal Correctional Institution located in Sandstone, Minnesota, has initiated 2 lawsuits alleging that the federal criminal mail fraud, wire fraud, and extortion statutes, the challenged statutes, are unconstitutional as applied. That's a key word, so there's facial challenges and there's as applied challenges. 2, activity he claims he may undertake at a unspecified future time. This court consolidated the suits upon finding that they involve a common question of law or fact. Hansmeier's complaints in the consolidated cases should be dismissed in their entirety because each of his claims fail pursuant to Federal Rule Civil Procedure 12b1, which is subject matter jurisdiction, and 12b6 because he's not entitled to relief, which is that those are the 2 parts of the Federal Rule Civil Procedure 12 regarding motions to dismiss. Facts. Hansmeier, an inmate at Federal Correction Institute Sandstone, pleaded guilty in August 2018 to 1 count of conspiracy to commit mail fraud and wire fraud in violation of the law, and 1 count of conspiracy to commit money laundering in violation of another law. In relevant part, Hansmeier, who was a licensed attorney, and another individual orchestrated an elaborate scheme to fraudulently obtain millions of dollars in copyright lawsuit settlements that involved obtaining the copyrights to videos for people over the age of 18, in some cases by filming the videos themselves and uploading them to file-sharing websites. After users downloaded the videos, Hansmeier and his co-defendant filed specious copyright infringement suits and petitioned courts to initiate discovery in order to send subpoenas to internet service providers to obtain identifying information associated with the IP addresses used to download the files. Hansmeier and his co-defendant, who I believe they're referring to John Steele, would then use extortionate letters and phone calls threatening the users with substantial financial penalties and public embarrassment unless they agreed to pay settlements, all while obscuring their involvement in the scheme from the courts. And when this is added to the videos on demand, because we're doing a live stream now, they will be part of the playlist of all of our Prenda Law videos. The short version of that paragraph, or the more detailed short version of that paragraph, is that Prenda Law used to put the lawsuit name and the defendant's name and a list of entertainment titles, including various different orientations of one's sexuality. So imagine something you might want to be embarrassed to be associated with, whether it be something for heterosexuals or something for homosexuals. They would put all of that on a website in an effort to embarrass people, and that was part of why they were charged. It wasn't the entire reason that they were charged, but it's one thing to pursue a copyright claim. It's another thing to pursue a copyright claim sort of plus, more than just the meritorious claim, but to try to embarrass users into wanting to get rid of their copyright claim as quickly as possible by sort of naming and shaming them. There is a threshold there where it becomes too much. But that wasn't the only reason that Prenda was charged. If that was it, maybe they would have gotten away with it. But there were other things, like at one point, I think it was Hansmeier had a gardener, literally a landscaper, who was named Alan Cooper, and he had him sign a document, and Alan didn't know what he was signing, and it turned out to be a fake copyright assignment so that Paul Hansmeier could submit it to the court and say, yes, we really do own a copyright. And at another point, Hansmeier and Steele were accused of uploading their videos to file sharing networks in order to seed BitTorrents to the file sharing, to then have defendants download it and create a potential situation to prosecute. Of course, if you upload it yourself, doesn't that some kind of implied license? Isn't that some kind of implied permission or something? If the owner of a copyrighted work puts it on the internet for downloading, isn't that some kind of legal download, not an illegal download? So that's more what they were charged with. Hansmeier was convicted, and in articulating its position in advance of his sentencing, the United States detailed Hansmeier's many abuses of legal process, which included lying to judges in order to fraudulently procure subpoenas to further his schemes. Hansmeier was sentenced to 168 months of imprisonment on both counts to be served concurrently, and was ordered to pay over $1.5 million in restitution. Hansmeier's appeal of his criminal conviction remains pending before the Eighth Circuit. Hansmeier has initiated 2 lawsuits, both of which the federal defendants removed to federal district court. That means that he initiated the lawsuits in state court, and then the federal defendants used a process called removal. You literally file a notice of removal, and a federal case is created, and then the court evaluates whether the state court matter really belongs in federal court. And if it does, then it gets adjudicated in federal court instead. And since these were federal claims, copyright's a federal claim, and Americans with Disabilities Act is a federal claim, it belongs in federal court. He alleges that the federal mail fraud, wire fraud, and extortion statutes are unconstitutional as applied to him because they prevent him from assisting unidentified individuals with pursuing claims against a gentleman's club, which Hansmeier claims discriminates against people with disabilities.
Okay. I have a question.
Yeah.
Usually lawyers that go to jail for committing fraud in the course of their practice don't get to keep their law license.
Right.
So would he still have the ability to assist people with
He
filing?
has already been disbarred, and you have the exact same question I have, which is how does he expect to represent someone else? Unless maybe he's an owner of this gentleman's club. Maybe that's the only thing I can think of, is if he would have to be an owner of this gentleman's club. Yes, other people have had this. Other people had this question too. Like, wait a second, how can he represent somebody if he's been disbarred?
Also, why would people want a former lawyer that is in jail for fraud to represent them? I'm sorry, but the U.S. is not short of lawyers. You do have a very high number of lawyers per capita.
I mean, at this point, I'd almost prefer Leibowitz over Paul Hansmeier or John Steele trying to represent somebody in these cases. That's where we're at. The second suit alleges that Hansmeier owns the copyright of a video and that Hansmeier directed an investigator to publish that video on a website for people over the age of 18. Hansmeier further alleges in his complaint that on June 29, 2020, the unidentified John Doe defendant accessed and copied the video, infringing on Hansmeier's copyright. And I have a problem with this. If you put the video on a website, isn't it perfectly legal for me to go and make, let me get a little technical here, an HTTP GET request for the file, and then your web server responds and says, sure, here's the file. Isn't that an ask and a receive? May I have this file? Yes, you may have this file. So isn't that an implied license or otherwise permission? I want you to have the file because I put it here for you to download. That's...
Someone in chat said that it's kind of the equivalent if someone's like, can I have an apple? And then you give them an apple and then you're like, you stole my apple. Yeah. It doesn't quite work like that.
Now, I could see setting up a website that says you're only allowed to view this file on our website and you're not allowed to download it and keep it. And then if they have like some kind of evidence that you downloaded it and kept it. But you know what that is? That's a terms of service violation. That's a contract violation, not a copyright violation. At least to the best of my legal research, which I admit I haven't really refreshed that research in a few years because I haven't dealt with that particular issue in a few years. But yeah, I understand that just because there's an image on Twitter that you can't just say, well, they gave you permission to use that. But we're talking about like viewing that image. Just are you allowed to view that image? Are you allowed to view their video? Now, I'm sure that there's maybe some technical detail that we're overlooking. Maybe he doesn't want the defendants to download the videos, but then you would just need to properly configure your web server not to allow that. And then if somebody, maybe I'm getting a little too technical here, but there should be ways to prevent people from downloading files from your website if you don't want them to. But, okay, so let's keep going because we're just going to go in circles here from now. Hansmeier alleges that he wishes to bring claims against John Doe for copyright infringement and violations of the Computer Fraud and Abuse Act using a strategy he did not employ previously, although this sounds almost exactly like the strategy he employed previously. Now, the Computer Fraud and Abuse Act, which is actually it says CFFA, but it's the CFAA. It contains a provision that basically stealing someone's username and password is a violation of the Computer Fraud and Abuse Act. But I don't think downloading a video from someone's website, just that by itself, is a violation of the CFAA. But that's something that Hansmeier's been trying to do. He has previously tried to use the CFAA. One of the reasons he's in jail was he had filed a lawsuit with some 5,000 or 6,000 defendants, and then he had one of the defendants that he had figured out by, I guess, a username or something who it was. He had them sign a consent decree that this person consented to a subpoena for all 5,000 or 6,000 people to get subpoenas and demand letters and all that. And all based on a very tenuous or empty violation of the Computer Fraud and Abuse Act. He says that he has not employed this strategy previously, but that he is chilled and prohibited from doing so, from pursuing these copyright violations or CFAA violations, by the credible threat of jeopardy he faces under the federal mail fraud, wire fraud, and extortion statutes. So in other words, he is afraid he's going to be charged with a crime. They're going to add something to his charges and try him under new charges. In both suits, Hansmeier alleges that the challenged statutes violate the First and Fifth, as well as the separation of powers considerations in the Constitution, First and Fifth Amendments. Hansmeier also asserts a claim for intimidation, coercion, threats, and interference by the government, while his other case alleges that the challenged statutes violate the 10th Amendment, the separation between federal and state powers. In both suits, Hansmeier seeks a declaratory judgment plus injunctive relief to prevent the federal defendants from enforcing the statutes against him. And so we're going to get a little bit of a lesson here from the United States Attorney about speculation, why you can't go to court with speculative why you can't ask a court to say, what you're about to do is perfectly legal. That's not something that you're ever allowed to do. And really, any educated attorney would know that you can't take something like that to court and ask a court to say, yeah, you're allowed to do future conduct that we haven't seen you do yet is totally legal. There has to be something more imminent than just the fact that there is a law and you could be charged with something if you violated the law. Because of course you could be charged with something if you violated the law. But we also haven't seen how you did it yet. But let's see what the U.S. Attorney has to say. Legal standard. If the court determines at any time that it lacks subject matter jurisdiction, the court must dismiss the action. In evaluating a motion filed pursuant to Federal Rule of Civil Procedure 12b1, the court must accept the well-pled allegations in the complaint as true and draw all reasonable inferences in favor of the plaintiff. A complaint must also be dismissed if it fails to state a claim upon which the court can grant relief. Although the court must take all non-conclusory allegations in the complaint as true, to survive a motion to dismiss, the complaint must contain enough facts to state a claim to relief that is plausible on its face. A claim has facial plausibility when the pled factual content allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. The court may grant a motion to dismiss on the basis of a dispositive issue of law. The court need not resolve all questions of law in a manner that favors the complainant. Rather, the court may dismiss a claim founded upon a legal theory that is close but ultimately unavailing. Further, the court shall review before docketing, if feasible, in any event, shall review before docketing, if feasible, or in any event as soon as practicable after docketing, a complaint in a civil action in which a prisoner seeks redress from a government entity or officer or employee of a government entity. The court must dismiss on this basis if the complaint is frivolous, malicious, or fails to state a claim upon which relief may be granted. What is the U.S. Attorney doing there? We have sort of a procedure we go through. We identify the issue, then the rule of law, then the analysis, and then a conclusion, IRAC or CRAC, conclusion, rule, analysis, conclusion. So that's just sort of a 2-paragraph summary of the rules involved. And if that went over your head, that's a little bit okay, because that's really complicated. There's a lot of jurisdictional law in there. A whole year of law school was just summarized in one or 2 paragraphs there. So don't feel bad if you don't quite get that, but we'll explain it along the way. So here's her analysis. Hansmeier's complaints should be dismissed in their entirety. His constitutional, declaratory judgment, injunctive relief, and Americans with Disabilities Act claims all warrant dismissal, either because they lack subject matter jurisdiction or they fail to state a claim upon which relief may be granted, or both. Hansmeier asserts as applied constitutional claims pursuant to the First, Fifth, and 10th Amendments, as well as pursuant to separation of powers considerations. He does not assert any claim in either suit that the challenge statutes are facially unconstitutional. He's just saying that they're unconstitutional because they're being applied to him unfairly, not that the statutes are illegally unconstitutional as they're written. It's instead as they're being applied to him. Because he proceeds pro se, or by representing himself without an attorney, his complaint must be liberally construed, as in other words, the judge will grant him some leeway. That said, pro se plaintiffs are not excused from establishing proper jurisdictional bases for their claims, and it warrants mention that Hansmeier was a practicing lawyer before his law license was suspended. Hansmeier bears the burden of establishing that jurisdiction exists. Both standing and ripeness are requirements for Article 3 subject matter jurisdiction. Absent either, subject matter jurisdiction is lacking. So subject matter jurisdiction is going to be the court's ability to hear a case involving the subject matter. So Americans with Disabilities Act claims, copyright claims are all federal subject matter jurisdiction. The concepts of ripeness and standing are closely related. However, while standing and ripeness overlap, they nonetheless require distinct inquiries, whereas ripeness is concerned with when an action may be brought. Standing focuses on who may bring a ripe action. The ripeness requirement demands that there be a real, substantial controversy between the parties having adverse legal interests. This is the case and controversy requirement. The U.S. Constitution literally says that the courts can only hear live cases and controversies. So ripeness and mootness are part of the case and controversy requirement. A claim is not ripe for adjudication if it rests upon contingent future events that may not occur as anticipated or indeed may not occur at all. The ripeness doctrine prevents federal courts from entangling themselves in abstract disagreements. While the question of the facial validity of a statute may be ripe for adjudication, the question of the constitutionality of the statute as applied may not be ripe. If you're following along with that IRAC or CRAC format, you notice that she just did it again. There was another issue nested within an analysis. So now that was just the rule paragraph again, and now we're going to have a nested analysis paragraph. With regard to standing, a plaintiff must demonstrate that he has suffered an injury in fact actually this is another rule paragraph, an invasion of a legally protected interest which is A, concrete and particularized, and B, actual or imminent, not conjectural or hypothetical. You can see where she's going here. She's going to argue that this is hypothetical. Allegations of possible future injury do not satisfy the requirements of Article 3, a threatened injury must be certainly impending to constitute injury in fact. Standing is determined at the time the complaint is filed. This court lacks subject matter jurisdiction to consider Hansmeier's constitutional claims because they are not ripe, because Hansmeier lacks standing to bring them, or both. Dismissal is warranted. In addition, several of his constitutional claims fail to state a claim upon which relief can be granted, and dismissal is warranted by 12b-6. In both suits...
So, if I could just summarize, because there was a lot that was just said there, but it sounds like the reason why this should be dismissed is because he's talking about a hypothetical harm that could possibly come about, but not one that's imminent. And so in order to have standing, like in order for this to be ripe for the courts to look at it, it has to be something that has already happened or something that is about to happen.
Yeah. And
it can't just be plausible in the future.
Yeah, he has to point to it's literally about to happen, there has to be something more concrete to the imminency of it about to happen. It can't be, I'm fearful that if I was to pursue this, I would get charged. While it might be nice for every one of us to ask a court for permission to conduct ourselves, I'd like to run a Ponzi scheme, but I want to do it in a legal way. Could I please petition the court for a declaratory judgment that I can run my Ponzi scheme this way and I won't be charged? That's not something that any court is ever going to allow you to do. Not because Ponzi schemes are illegal, they are, but because no court is going to speculate as to how you're going to conduct yourself. And that request kind of violates the separation of powers, because the prosecutor has the discretion to choose when to charge and whether to ask the court on these details, on these specific facts, things that actually happened. We think that there was a criminal act that we can prove beyond a reasonable doubt. And so it's hard to ask a court to rule sort of about that reasonable doubt before something has actually been done. I sort of get the idea that it would be nice to have a ruling sometimes, but you also, you could imagine the courts being quite overwhelmed with speculative judgment requests, declaratory judgment requests, because people want to commit something that is very close to a crime and not be charged with a crime. He claims that, as applied, the challenge statutes chill him from undertaking a plan to aid and encourage people with disabilities to petition the courts for relief to address the Gentlemen's Club's ongoing discrimination against people with disabilities. He alleges that he is injured because he is placed in the position of either refraining from this plan or of exposing himself, no pun intended, to the risk of prosecution, and that refraining from conducting his plan constitutes, self-censorship and a loss of his First Amendment rights. In the second consolidated case, he alleges that he has been chilled from pursuing his Copyright Enforcement and Computer Fraud Abuse Act claims against a John Doe defendant by the credible threat of jeopardy he faces as a result of the federal defendant's application of the challenge statutes to him. To establish injury, in fact, for a First Amendment challenge, a plaintiff need not have actually been prosecuted or threatened with prosecution. In this context, a plaintiff can establish standing in two ways. One, by alleging an intention to engage in a course of conduct arguably affected with a constitutional interest but proscribed by a statute, and there exists a credible threat of prosecution thereunder. So, it sounds like he's at least got the right sort of idea there. Or two, by alleging self-censorship upon a credible threat of future prosecution. So he's not completely off. It warrants emphasis that an allegation of self-censorship does not end the inquiry. However, a party's decision to chill his speech in light of the challenge statute must be objectively reasonable. A speculative risk of prosecution is not a credible threat sufficient to confer standing. In addition, non-criminal consequences contemplated by a challenge statute can also contribute to the objective reasonableness of an alleged chill. Hansmeier fails to plead facts that there is a credible threat of future prosecution or civil enforcement for the planned or anticipated activities he describes in his complaints. In the ADA claim, though he alleges that he was threatened in the past with prosecution on other unspecified efforts to aid and encourage people with disabilities to enforce their rights under the ADA, nowhere does he allege that he has been threatened with prosecution if he employs the strategy he details in his complaint. Similarly, in the copyright claim, he specifically alleges that his planned conduct differs meaningfully from the conduct for which he was convicted, in order to proactively address many of defendants' allegations of wrongdoing. What is more, Hansmeier alleges that his plan, as opposed to his past conduct, will eliminate any reason for defendants to claim that Hansmeier is concealing his use of an investigator or his involvement in the claims. In other words, Hansmeier proposes a new strategy to pursue copyright and CFAA claims against John Doe than for that for which he was prosecuted, and he offers nothing whatsoever to support a conclusion that there exists a credible rather than a hypothetical risk of prosecution in connection with this new strategy. Hansmeier's belief that he could find himself subject to prosecution or civil liability if he pursues these novel strategies is not the same as alleging the fact that he is indeed subject to a credible threat of prosecution. While general factual allegations of injury might suffice to establish standing in some instances, general allegations of possible or potential injury do not. Nor is it at all clear from the complaints that the conduct Hansmeier may potentially engage in is even prescribed by the mail fraud, wire fraud, or extortion statutes. Hansmeier lacks standing, and the First Amendment claims should be dismissed. I don't know. I feel like that the attorney did not go into a lot of detail there about where exactly the line is between Hansmeier's conduct and what would be, where would the line be between his intended conduct, because we did a video on this. You can go watch our video from June or July of last year, and that'll be as part of the playlist when we get this in as a VOD. We go over what the details were of his new copyright honeypotting scheme, which is basically that he's going to own the copyrights correctly, and he's going to use an investigator correctly, and he's going to upload videos and then let people download them and then try to prosecute them. There's some pretty good defenses there, but maybe those are civil defenses for the defendants to defend themselves with. And although I don't see this as a promotion of the sciences and useful arts, I don't see this as a core promotion of copyright, the courts will be able to adjudicate that. I don't think he's going to be prosecuted by the U.S. attorney for criminal charges of mail fraud, wire fraud, or extortion if he follows the established law on pursuing copyright claims. Remember, I represent defendants in Malibu Media and Strike 3 Holdings, BitTorrent, copyright infringement, downloading, file sharing, piracy matters, and Hansmeier went much farther than that. Didn't own the copyrights in some cases, lied to the courts in other cases, basically forged signatures in other cases. This was not the same thing as having a meritorious copyright claim and then simply aggressively pursuing it. We can disagree on the aggressive pursuit or prosecution all day, but I don't think that aggressive prosecution of a civil copyright infringement claim based on BitTorrent copyright infringement is going to get you criminal charges unless there's something of a misrepresentation, of a fraudulent misrepresentation going on there. Let's see. Robert Mail, thank you for the $5. I know you're a few hours into the future. Is 2021 any better than 2020? Oh, I really hope so. I'm going to talk a little bit about what's going on with me personally at the end of the video, because I don't want to put a damper on anyone's celebration, and I'm going to put up a big disclaimer before we talk about that. So let's just continue, and then we can get to that at the end. Fifth Amendment claims. So Fifth Amendment is the right against self-incrimination, the right to due process. In both suits, Hansmeier claims that the challenge statutes are unconstitutionally vague in violation of the Fifth Amendment, so that would be due process, as applied to him, to planned and anticipated conduct he alleges he may undertake. According to the void for vagueness doctrine, a law is unconstitutional, as applied, if it fails to provide a person of ordinary intelligence fair notice of what is prohibited, or is so standardless that it authorizes or encourages seriously discriminatory enforcement. So that's the words right out of the U.S. Attorney's fingers typing on the keyboard. Citing the proper citations here from the Supreme Court and the Eighth Circuit Court of Appeals about how you can get rid of a law for being too vague. And so, Hansmeier can take this motion to dismiss and decide for himself whether he's going to be violating the law or if the law is not clear enough or something. But I don't think the law is that unclear, nor does the U.S. Attorney. Here, Hansmeier's Fifth Amendment as applied claims are not yet ripe. In the ADA claim, he alleges that he intends to undertake certain activities, that he wishes to act and has the goal of acting, and that if carried out, he believes his plan would result in injury to him. Elsewhere, he describes his activity as planned conduct. He pleads that he has already begun some of the activities that are part of the plan described, but without more, that is not sufficient to demonstrate the ripeness of these claims. Similarly, in the copyright claim, he pleads only that he wishes to act and that he has certain anticipated claims, where a plaintiff fails to allege beyond conjecture what may happen if he chooses to undertake a course of action. It amounts to a hypothetical, based on contingent future events. Hansmeier also lacks standing to assert his as-applied void for vagueness claims for two distinct reasons. First, for a plaintiff to have standing to challenge a statute as vague, the statute must be unconstitutional as applied to his specific conduct at issue. But in neither case has Hansmeier alleged facts sufficient to establish standing, because there is nothing to suggest that the conduct in which he allegedly wants to engage involves clearly prescribed conduct. Second, Hansmeier has not alleged any adequate injury for purposes of Article 3 standing. While Hansmeier incants in both cases that he suffers ongoing and irreparable harm, nowhere does he specify what actual current harm he is suffering. Such bald allegations of injury without more are not enough to avoid dismissal. Because Hansmeier's Fifth Amendment claims are not ripe, and because he lacks standing to bring them, the court lacks subject matter jurisdiction over them, and dismissal is warranted. Again, I think the U.S. Attorney could have done a better job, and this is not like a major criticism. This is probably quite an adequate, not inadequate, but an adequate declaration or statement of the law and an analysis. I just think the U.S. Attorney just doesn't want to put any more detail into this, but maybe she could make clear exactly where the line is for him and what he should have done, and how he falls flat, instead of just stating the law and saying, this is the law and he does fall flat. She's kind of leaving it up to the judge to fill in the blanks, in my opinion. And it's not a super, Ms. McDonald, if you're watching this, it's not a serious criticism. I'm just looking at this sort of academically and saying, okay, there probably could be more detail in this. At the same time, there probably could be more detail to Hansmeier's claims in the two lawsuits that are consolidated. He goes on with separation of powers claims. In both suits, and this is, again, Attorney McDonald speaking, Hansmeier claims that as applied to him, the challenge statutes unconstitutionally intrude upon Congress' powers to make the law and the judiciary's power to interpret it. For the same reasons, Hansmeier lacks standing to bring these claims. Further, any argument that the federal defendants intrude upon Congress authority by prosecuting the challenge statutes is unavailing. The Eighth Circuit has recognized that the Attorney General, under which the federal defendants operate, acts within his authority when he delegates intra-agency to accomplish the duties given to him by Congress. So he's part of the executive branch, or the Attorney General is part of the executive branch, so it's not a violation when the laws are enforced by the U.S. attorneys, is maybe my summary of it. Congress has specifically authorized the Attorney General and the U.S. attorneys to prosecute criminal offenses, including the mail fraud, wire fraud, and extortion statutes. The separation of powers claims fail, which is basically what I just said. The 10th Amendment claim fails. In the copyright claims, Hansmeier additionally claims that the challenge statutes are unconstitutional as applied to him because they impermissibly intrude on the power of the states to create and administer courts and to decide claims presented to them. Which is a weird claim because copyright is a federal law issue. Maybe he's talking about the Computer Fraud and Abuse Act, but that's also a federal law. I'm not as familiar with it. Maybe there's a way that a state law claim is made in there, but I'm pretty sure it's a federal law claim for the Computer Fraud and Abuse Act. Hansmeier alleges only that he wishes to bring copyright infringement and CFAA claims against the John Doe defendant, not that he has done so. Hansmeier also lacks standing to raise this claim. His 10th Amendment claim is anticipatory. He is not currently a criminal defendant in any action relating to the conduct he wishes to undertake, and thus is not a party to an otherwise justiciable case or controversy as required to establish standing. Even if Hansmeier's 10th Amendment claim were ripe, and even if he had standing to assert it, it would nonetheless fail. The Eighth Circuit has clearly held that the mail fraud statute is a legitimate exercise of Congress's postal power. It is similarly well settled that the wire fraud statute is within the extensive reach of the Commerce Clause. So the postal power these are the powers that give Congress the right to make federal laws. And if Congress doesn't have the power to make a law under an enumerated power in the Constitution of the United States, then those powers fall to the states to enforce. So health and welfare generally falls to the states unless it involves, say, the Interstate Commerce Clause, where the federal government needs to regulate commerce between the states. But if it's within a state, that falls to the state's powers. Likewise, the postal power, the right to set up the post office and enforce laws regarding the postal service, that's a federal power. So mail fraud using the postal service, that's something that the federal government can prosecute. When you're committing fraud between states, that's something the federal government can prosecute and does not violate the 10th Amendment. And so she says that right there, that the statute does not violate the 10th Amendment, and that claim fails. Then there's something called the Heck Doctrine. The Heck Doctrine provides that a civil damages case cannot proceed if its success would necessarily imply the invalidity of a criminal conviction, unless the prisoner can demonstrate that his conviction or sentence has previously been reversed on direct appeal, expunged by executive order, so like a pardon, I guess, or otherwise invalidated. Although the Heck case involved a 42 U.S.C. 1983 civil rights claim, actions seeking non-monetary relief, such as Hansmeier's constitutional claims, may not proceed where they would call into question the lawfulness of his detention. And then she gives a bunch of examples. Simply put, the Heck Doctrine is intended to prevent a collateral attack on a conviction through the vehicle of a civil suit. A claim barred by the Heck Doctrine is subject to dismissal as failure to state a claim, 12b6. As a threshold matter, Hansmeier does not allege that his conviction has been invalidated, nor can he. His appeal of his criminal conviction remains pending before the Eighth Circuit, and we'll keep an eye on that, and if anything changes, if the Eighth Circuit has anything to say other than, we affirm Hansmeier's conviction, then we're going to present that to you here on our channel. Because Hansmeier's conviction stands, and because if Hansmeier were to prevail on his constitutional claims, it would necessarily imply the invalidity of his conviction, such causes of action are barred by the Heck Doctrine. Hansmeier's attempts to avoid this result through artful pleading, I guess I misread that, but I'm going to add fail. But despite Hansmeier's efforts to frame his allegations as oriented towards alleged anticipated conduct, the relief he seeks is much more sweeping. Findings that the challenge statutes violate the First, Fifth, and 10th Amendments, as well as separation of powers considerations. So if the court was to find that all these violations were sound, that they were violations, then they would also sort of act as an appeal. but he has an appeal pending, so he can't use this to backdoor an appeal in, basically, is what I think she's saying here. Tellingly, Hansmeier has made such arguments already in his criminal case. They were rejected. He argued that mail fraud and wire fraud were constitutionally invalid, and that the theory of mail and wire fraud advanced by the government in his case violated the First and Fifth Amendments, as well as the constitutional separation of powers concerns, and they were denied. Hansmeier cannot convincingly argue that the instant suits are unrelated to his criminal conviction. Indeed, he specifically describes his criminal matter as at issue in this case. Hansmeier's latest effort is exactly what the Heck Doctrine prescribes, a collateral attack on a conviction through the vehicle of a civil suit. For this additional reason, his constitutional claims should be dismissed. And then she goes into his declaratory judgment. That's when you're asking a court to say something is legal or illegal. I use declaratory judgment claims as counterclaims in my copyright defense suits. So we want the judge to declare that my client did not commit copyright infringement when they are accused of copyright infringement. Hansmeier's declaratory judgment claims should also be dismissed in the absence of a jurisdictional basis for such claims. Although liberally construed, a pro se complaint must nonetheless set forth the proper jurisdictional bases for the plaintiff's claims. In order to pursue a declaratory judgment action in federal court, therefore, the court must have an independent basis for jurisdiction. In the ADA claims, Hansmeier pleads that the court has jurisdiction over his claims pursuant to the Participation Clause of the Americans with Disabilities Act and the First and Fifth Amendments to the Constitution. To the extent that Hansmeier seeks to rely solely on subject matter jurisdiction to confer jurisdiction over his declaratory judgment claim, he cannot. As already explained, the court lacks subject matter jurisdiction over his constitutional claims, and those claims are additionally subject to dismissal for failure to state a claim 12b6. As a result, the subject matter jurisdiction on its own is not a sufficient basis for subject matter jurisdiction to support the declaratory judgment claim, nor does the Americans with Disabilities Act confer jurisdiction on this court to issue the declaratory judgment he seeks. He fails to identify any appropriate basis for subject matter jurisdiction over his declaratory relief claim, and dismissal is warranted. As to the copyright claims, Hansmeier pleads that this action arises under the U.S. Constitution and that this court may award declaratory and injunctive relief pursuant to the Minnesota Declaratory Judgment Act and this court's inherent equitable jurisdiction. For the reasons already stated, 1331 is not a sufficient claim to confer subject matter jurisdiction, or 1331, the subject matter jurisdiction, is not sufficient to confer subject matter jurisdiction for a declaratory judgment claim. The confusing part of this is that he brought these as state court actions. So, is it really meritorious to say that that the federal court is supposed to have subject matter jurisdiction when it was the U.S. attorney that removed it to federal court? At the same time, he's talking about wanting a declaratory judgment, and he wants it on a copyright claim, which is federal subject matter jurisdiction, and an Americans with Disabilities Act claim, which is federal subject matter jurisdiction. So they're in the right court, and so it's kind of interesting. She removes it to federal court and then says, we're in the right court for these claims, but he still didn't state a claim, and he still doesn't have proper jurisdiction. Any argument that the court has subject matter jurisdiction to issue a declaratory judgment pursuant to its inherent equitable jurisdiction is unfounded. So the courts of equity or the claims in equity are saying something is unfair, and that the court inherently has some power to make a ruling about fairness. And that's not quite how you get subject matter jurisdiction. So for the declaratory judgment action, I think you have to have an underlying claim that needs a declaratory judgment, and you still have to have subject matter jurisdiction. In order to have subject matter jurisdiction, you have to have standing and ripeness and not mootness, and he doesn't have ripeness and he doesn't have standing, so therefore doesn't have subject matter jurisdiction, even though it is the correct subject matter. It's the ripeness and standing parts that we talked about before. The extent that Hansmeier asked the court to assert supplemental jurisdiction over a declaratory judgment claim Okay, so supplemental jurisdiction is when you have a federal cause of action primarily, and then you also want the federal court to adjudicate a state claim along with it. But you have to have a federal claim first. So if he doesn't have the federal claim, then he also won't have supplemental jurisdiction. So to the extent that he asks the court to assert supplemental jurisdiction over a declaratory judgment claim, the court should decline to do so. The Eighth Circuit Court of Appeals has been clear that Congress unambiguously gave district courts discretion to dismiss supplemental state law claims when the federal claims have been dismissed. So it's a domino effect. It's a knock-on effect. If his federal claims are dismissed, then his supplemental claims are dismissed too. The court should exercise its discretion here and decline to consider any state law claims. Finally, even if Hansmeier means to invoke the declaratory judgment, even if I think that's a misplaced possessive apostrophe there. Even if he means to invoke the Declaratory Judgment Act, his argument failed. It is well settled that the Declaratory Judgment Act cannot provide an independent basis for exercising jurisdiction. Even if the court were to conclude that it has jurisdiction over the declaratory judgment claims, to which Hansmeier refers in the copyright action, such a claim would fail for a second reason: he has failed to articulate an actual live controversy in either case. So back to the standing and ripeness issue. By his own admission, he seeks a declaratory judgment to obtain advance ratification of planned or anticipated activity. Nowhere does he plead that he will pursue his claims with any immediacy. His declaratory judgment claims boil down to a request for an advisory judgment, and the Supreme Court has long made clear that a declaratory judgment procedure may not be made the medium for securing an advisory opinion in a controversy which has not arisen. For this additional reason, his declaratory judgment claims fail. And they're not warranted for yet another reason. Just as Hansmeier's constitutional claims are heck-barred, so are his declaratory judgment claims. In the ADA claims, he seeks a sweeping declaration that the challenge statutes violate various constitutional rights. In the copyright action, he alleges that he is entitled to a declaration that defendants cannot lawfully enforce the law against him. And he requests that the court declare that, with regard to copyright enforcement claims, that the law violates the First, Fifth, and 10th Amendments. Such far-reaching declarations would impermissibly undermine his conviction, and so the Heck case applies there as well. He also asks for injunctive relief. I swear we're almost done. Hansmeier's injunctive claims should also be dismissed, both because this court lacks jurisdiction to order the requested relief and because Hansmeier's complaints fail to state a claim. We know that already. He seeks to enjoin federal defendants from enforcing or threatening to enforce the challenge statutes against him in connection with his anticipated copyright claims against John Doe's and his planned conduct relating to ADA enforcement. As he failed to do so with respect to his claims for declaratory judgment, he does not identify any basis for this court's jurisdiction. So in order to get injunctive relief, he needs additionally irreparable harm and likelihood of success on the merits, that the threatened injury outweighs any threatened harm, and that there is a public interest involved. The party seeking injunctive relief bears the burden of proof. He cannot show that he has a likelihood of success on the merits. He is not likely to prevail for reasons already discussed. Serious questions regarding a court's jurisdiction weigh against entry of injunctive relief because potential impediments to even reaching the merits make a plaintiff's claims less likely to succeed. Nor has Hansmeier made any effort to plead how he will suffer irreparable injury in the absence of an injunction, or that the threatened injury to him without equitable relief would outweigh harm to the federal defendants if the court grants an injunction. His repeated incantations that the federal defendants are causing outgoing or ongoing and irreparable harm are not enough. Finally, though Hansmeier purports to believe that his planned conduct serves some public interest, his complaint does not allege this adequately. And so the federal defendants are responsible pursuant to the Attorney General's delegated authority for enforcing federal criminal law. They have an interest in, and the public interest is served by, preserving prosecutorial discretion. What did I say before about prosecutorial discretion? Exactly this. I should be a U.S. attorney. Hansmeier also claims intimidation, coercion, threats, and interference by the prosecutors. Other than making a passing reference to concurrent jurisdiction over federal causes of action, Hansmeier does not explain how this court has jurisdiction over this specific claim. He suggests only that the court has jurisdiction pursuant to the Participation Clause with the Americans with Disabilities Act. But the provision to which Hansmeier refers provides, in relevant part, that it is unlawful to coerce, intimidate, threaten, or interfere with any individual on account of his or her having aided or encouraged any other individual in the exercise or enjoyment of rights protected under the ADA. It does not confer jurisdiction on this court to consider Hansmeier's claim against the prosecutors, however, and the dismissal is warranted. Even if the court had jurisdiction to consider the claim, the plaintiff must show that when the interference, coercion, or intimidation that took place, they were exercising or enjoying a right protected by the ADA. Hansmeier's complaint specifically alleges that he wishes to undertake planned conduct. He does not allege that he was subjected to interference, coercion, threats, or intimidation for the articulated planned activities, but instead for past activities, so Heck Doctrine. And while he makes a vague reference to having already begun some of the activities that are part of the plan discussed above, he notably does not allege that he was subjected to any interference, coercion, threats, or intimidation when he undertook such unidentified activities. Indeed, of particular note are Hansmeier's allegations that the federal defendants will intimidate, coerce, threaten, or interfere with him, not that they have done so in connection with his planned conduct. Dismissal of this claim is warranted, and everything should be dismissed. And that's Erica H. McDonald, U.S. Attorney for the District of Minnesota. And the court has not ruled on that yet, so we'll get to see what the court has to say. I have a feeling that all of this is just foreshadowing to Prenda Law Part 2, where Hansmeier tries to represent himself in his own copyright enforcement scheme, and I guess Americans with Disabilities Act enforcement scheme, from prison, which, that's remarkable, and I mean that literally, that is something unique that we can remark on, because I really don't understand what this guy, to not be, I don't want to use the metaphor, he is very attracted to this sort of prosecution of these Americans with Disabilities Act claims. And although there is a thing called Americans with ADA trolling, basically, where a attorney will find disabled defendants, have them attempt to access a business, have some sort of interference with accessing that business, and then go in and threaten the business with an ADA lawsuit if they don't pay a settlement. That can be something that is disruptive to the business. On some level, that's what the ADA was written to do, though, was to get businesses to comply with the ADA. So, but there's also a point where a plaintiff's attorney may be too aggressive and make legal threats against businesses that haven't actually committed a violation of the Americans with Disabilities Act, and might coerce those businesses into paying settlements even though they weren't violating the ADA, simply because it's easier to pay a settlement than it is to defend oneself in court all the way through some sort of adjudication, whether that be summary judgment or a judge's bench trial or a jury trial. It's very expensive. It's federal court. Lawyers are more expensive in federal court, generally speaking, than in state court. And you also need an attorney that is well-versed and competent, Rule 11 competent in the Americans with Disabilities Act or in the Copyright Act. Same thing with copyright law. Just like copyright trolls, you have ADA trolls. And so just like ADA trolls, you have people who will look for any minor technical violation of copyright law and threaten to pursue maximum damages. And sometimes a business or person should settle those claims, and other times someone will settle those claims just because those claims are expensive to defend. And so these are what we would call nuisance lawsuits. Some of them are legitimate, some of them are nuisance lawsuits. So I'm not necessarily characterizing all copyright enforcement as nuisance lawsuits, nor all Disabilities Act lawsuits as nuisance lawsuits. But there is some level of nuisance lawsuit to many of those claims. And Paul Hansmeier is not in jail for simply being a nuisance lawsuit plaintiff's attorney. He is in jail for committing fraud in prosecuting his nuisance lawsuits. That's what that's all about. And the really, really remarkable part about all this is that he's trying to now restart his nuisance lawsuit engine and get his train rolling down the tracks to lucrative prosecution from prison while he is suspended from the practice of law. So he can't represent anybody else except businesses that he started himself or owns himself. And what we have seen him do before is try to create copyrights or buy copyrights, or maybe he has some ownership interest in that LLC, the Entertainment Club for Gentlemen, and maybe he's going to try and prosecute something from prison to try and make I guess a little bit of money. I mean, there's only a couple $1,000s really at stake in any one of these things. So I'm not really sure. Is he going to try and start some kind of en masse copyright infringement prosecution scheme so that he can pay off his $1.5 million in debts and fines and restitution from his criminal prosecution? Maybe that's what he's trying to do. He's got.
I mean, aren't there also rules about non-lawyers having a stake in law firms or owning or managing law firms? So, like, even if he's suspended or disbarred, he can't even be in charge of other lawyers and tell them what to do, as far as I understand.
Right. He would not be able to own a law firm, but he could own the club, and he could represent the club. Now, this is weird. It's an LLC. Sometimes an LLC owner is not allowed to represent the LLC because there's a conflict of interest between the personal interests of the owner and the interests of the LLC. So sometimes you have to get an attorney to represent the LLC. So I'm not sure, and I mean that literally, like, I'm really not sure exactly how legal it is for him to represent an LLC. That's going to be something, I guess, under Minnesota state law, whether or not he's allowed to represent the LLC. He's certainly suspended from the practice of law, so he can't represent them in an attorney-client capacity, but maybe he can represent it in an ownership capacity. I'm really not sure about that one. That's the only vehicle through which I could see him representing that way. With the copyright claims, I believe he is either buying or creating new copyrighted material or using copyrighted material that he already owns. You can certainly buy copyrights and register copyrights while you're in prison. And if he wants to explore creating a copyright honeypot scheme, which it sounds like what he's doing, by putting copyrights into circulation and then suing people for the illegal usage of that, I mean, good luck. Everyone who sees his name on one of these things should be able to Google him. He's got a unique name, and they should see that this is something to be seriously questioned. I see this going the way of Leibowitz. The further he gets into copyright trolling, the more likely he will make some mistakes along the way and either subject himself to criminal prosecution or at least sanctions, and I don't foresee that his train is going to roll very far down the tracks. And I think you might interpret these lawsuits as, his anticipation of that, because why would he file for a declaratory judgment or injunctive action if he didn't think he was walking the line between legal and illegal activity? if it's that close to being illegal activity, why not just find a better way to do it? As a defense attorney, I always want to advise my clients to act, in the better safe than sorry realm of action. So if you're doing something that is arguably legal, but also arguably illegal, maybe you want to adjust your activity so that it's much more arguably legal and much less arguably illegal. If you could eliminate the prosecutor's discretion, if you think about a hypothetical scenario where if you got caught doing what you're about to do by a very aggressive prosecutor who does not like you and wants to pursue you to the ends of the earth, would you be clean or would you be open or exposed to prosecution? As an attorney, I'm going to advise you to avoid the conduct that is going to get you prosecuted. At the same time, there's Uber, the car share company, who arguably acted outside of the law since its inception and only built its empire by basically breaking every law and then later on going to various jurisdictions and saying, hey, we'd like to work with you now, and getting permission here and there and paying fines along the way, and somehow avoiding further prosecution than what we've already seen against Uber. So the risk takers of the world, do risk winning a great windfall as well. So maybe that's what he's hoping to do, and he's just trying to protect himself by getting a declaratory judgment and an injunction that he's not doing anything wrong. All right. Any other thoughts on that? Because, that's an hour-long discussion of copyright trolling and standing and various doctrines and how to write legal papers. And, maybe you could even see a little bit of the prosecutor not getting frustrated, but just sort of not wanting to put more effort into the details of why Hansmeier's matter fails. Again, not a serious criticism, just a note. Just like, okay, well, those sections could have been more filled out. At the same time, motions to dismiss like that often have a 24-page limit, and that was 23 pages. So maybe there just wasn't enough room to put every detail that the prosecutor wanted to put, or that the U.S. attorney wanted to put. So, we have lots of stories to cover, and anybody who's been a longtime supporter of this channel may have noticed that we were light in videos in December. And so I'm going to explain that in a moment, but first let me do my outro. Let me thank all of our supporters. This is a community-supported legal education channel. We're here on YouTube. We also do a Sunday morning, 10 a.m. Eastern show on twitch.tv/lawfulmasses. We have supporters on Patreon, on Sponsus, on Twitch, YouTube members, and via Floatplane. And we thank you all for your financial support on a monthly basis, either by becoming a member or by literally donating your money to us to help work on videos for you. In December, we have several $50 plus supporters that we call out by name, and they are Joe Tyson, Wes Delj, Mitchell Rowton, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Andy, Benjamin Hitov, Goliath Cleric, Ugly Grill, Shielo T, Rudolph Bescherer Jr., HotGrillsInYourArea, Oscar the Phrophet, Brandyn Abel, Torpedan, Cassandra Curran, Mayor of Titty City, ShadowTycho, RDHDragon, Earthbound Star, No Copyright Violation Intended, and Nathan McCarty. And we also have a bunch of $5 plus supporters. Everyone's scrolling on that Galaxy Tab 2 that I've got there, emulating an LED panel like I've got back in the States. And so thank you very much for everyone's support. I'm really glad that 2020 is going to be over. It was such a very stressful year. Now, let me give you a heads up. I do want to discuss just for a moment what's been going on with me personally. And this is a little bit sad. So if you don't want a damper on your, your evening, it's New Year's Eve for many people, and it's New Year's Day for some of us as well. Just turn this off now, and Happy New Year and all that. But just to discuss something that has happened here. Recently, my father was diagnosed with COVID-19. He was brought to the hospital on December 15th, very, very weak and had very low blood oxygen. And he fought COVID for about 10 or 12 days. And then they thought that he would recover. His blood oxygen was better, but then he passed. And he had a heart attack. They were unable to revive him. And so I promised myself I wasn't going to cry. But, here is my father's obituary. And so that has taken a bit of a toll on my ability to get videos out during this last few weeks here. So I apologize to you all for not being as productive as I would like to have been, and if anyone was wondering, that's why. My dad was a great dad. He overcame a lot of challenges in his life. He was able to give me a very good childhood and make me the person that I am today, and I am very thankful for his gift to me of being a great father. But unfortunately, he had several complications, some lung issues and diabetes, and he was a little overweight too, and he just wasn't in great condition to survive COVID-19. He wasn't an anti-masker or anything like that. They took the virus very seriously. He just caught it one day. He and my mom are leaders at their church, and they were doing social distancing things for the church to continue to have their church services. And we don't know for a fact that they caught it at church, but that's at least what we expect. But even though he was masked and trying to maintain sanitary conditions and everything, we still think that he caught it either from church or maybe from the grocery store, because there was an outbreak at the local grocery store. And so he and mom both caught COVID-19, and he went to the hospital. Mom just had mild symptoms of a bad head cold, and took her a little bit longer to recover than you would normally expect from a head cold, but she was never any worse than just a bad head cold. So we're doing okay. It's been a bit of a shock. He passed on Sunday night, and we've gotten over the shock, and now it's all of the things that remind you of the person and the sort of lack of any additional time. I'm really happy that my father and I started to see eye to eye and reconciled our differences in the last few years. He retired from his job. He had sort of he had like an industrial job for many years in steel, and then he shifted to a much an employee. He was an employee of the local school district for the second part of his life, or last part of his life, and then he just retired a couple years ago. And so I was hoping to have many more years with him, but that's what happened. So thank you all for your condolences. I'm sorry to put a damper on your evening. I hope that it's not a big damper. We're okay. Mom is okay. Kaylee and I are okay. He does not want any services. He's been cremated, and his remains have been returned to mom. And then we're going to have a celebration of his life later this year when people can get back together. So there's no tremendous urgency for me to travel So we're just going to take things one day at a time. And I will get back to making daily videos for you on a regular basis very shortly here, hopefully starting on with Sunday's show. So we're just taking things one step at a time. It's been quite a shock and quite a difficult past 2 weeks with all of that. And I thank you all for your patience with me. And thank you all for your kind words. I've been amazed by the outpouring of sympathy and kindness and support. I don't mean financial support. I really do appreciate the financial support, like the £10 that, where's my cursor here, that DN Seeing Shadow, and the £5 that Peter Jones just gave. I really appreciate the financial support, but I also mean just the supportiveness. My mom needed the snow, the walks shoveled, and friends came over to help. People have been sending food. One of my friends has been helping take care of my house back in Allentown since I can't get there, since the outbreak has been not under control in many places. So we wouldn't be able to do this without all of your love and support, both financially and otherwise. And I really appreciate your kindness, and just the sense of community that we have is very reassuring. So I love you all. I'm going to end the stream there. No pressure, Tactical, but did you have anything that you wanted to say before I close? It's quite all right if you don't.
I don't.
Okay. I didn't mean to put you on the spot. I'm really sorry, but I just wanted to, not step over you if you had anything to say. So everybody have a blessed and happy and safe new year. I hope that 2020 is better for all of us than 2021 is better for all of us than 2020 was. So I'm going to sign off. I love you all, and I'll see you in the videos that drop.